Welcome to Discovery IAS Academy's online platform. Now today we are starting crash course for Mains 2022. Crash course is a short duration course, but it is definitely very exhaustive and very intensive, so that you are able to cover all the topics in different subjects in a short span of time, preparing yourself to write near emphatic answers to score very high percentage of marks. This crash course will run for 40 days and will cover all subjects of GS, talking about various important and conventional topics, and we'll also discuss the questions which have been picked up from those topics and how to write answers. That is the most important thing. So this crash course would be really beneficial to you, and I'm dead sure that once you complete this course, you will be able to understand the demands of the question, as well as you will be able to write near perfect answers, at least in the sense that you are scoring very high percentage of marks and you will ensure your success. So from today we will be covering governance, constitution and polity. That is in your paper 2, and that covers quite a huge list of topics. It is in fact given very high weightage in paper 2, and almost 9 to 10 questions are generally asked from this segment. So it covers more than 100 marks out of 250 marks paper. So this has to be concentrated. You have to be concentrated during the class. At the same time, you have to be very particular in understanding the demands of the questions and the topics concerned. I'll show you the topics also, and then we'll pick up the questions every day, and we'll try to cover more or less every aspect in the polity governance. Another very important thing about crash course is that for writing answers, that is very important. Now, evaluation of the answers is again very important for you. So you may send the answers through our WhatsApp number, and that will help you to give your answers, send your answers, and then the teacher concerned will correct it, will review that, and will revert to you what is the suggestion and how to improve further if needed, what are the facts required, and how to change if needed, how to bring about changes in your answer to make it very powerful and very emphatic. So at the end of the class, I'll give you the phone number, and you may send the answer, as I said, through WhatsApp. So now let's start with this, and let us first have a look on the topics which include conventional also and emerging topics also, the recent developments also, and accordingly I'll tell you how we have framed the questions which are prospective questions for Mains 2022. Let's have a look at the topics first. Here it is written: important conventional topics, issues and concerns in federal finance, including the role of GST Council and the Finance Commission. This has been very much in news also. So this is not only conventional, this is also an emerging issue, emerging topic which one needs to cover. Then cooperative federalism, rights of women and children in the Constitution of India, challenges before implementation of the directive principles, role of CAG in ensuring accountability and transparency, then rights to freedom and reasonable restrictions, parliamentary proceedings, parliamentary committees. Then we have independence of judiciary in India, role of the judiciary in making the state accountable, impeachment of president and removal of judges. Then we have election of the president, preventive detention. Then fast track courts, contempt of parliament and of court, election and its management, Panchayati Raj institutions and their role in development, issue of enforcement of fundamental duties, rights to freedom of religion, and right to life and its various dimensions as explained by the apex court in India. These are the important conventional topics which you must cover and revise at home. Whatever sources you have, you should revise at home, and so that you are able to understand what I am discussing in the class. Then we have important emerging issues like issues and concerns in Uniform Civil Code. You must have read in newspapers. UCC has always been in news in the last few years. Then issue of marital rape. This has been in the news after a court's decision. It has become once again controversial. Then issue of hate speech, sedition law and the right to freedom of speech and expression. Then we have digital rights and their significance. Digital rights are essentially human rights in the era of internet. So these are also very, very important rights issues, and we need to cover this with depth also and with good concepts. Then we have community forest rights, then proposed amendments in the preamble, right to government aid. The court has recently said that right to government aid is not a fundamental right. Then right to be forgotten under Data Protection Bill. Then we have federalism and minorities, including the role of National Commission for Minorities, changes in cadre rules, Permanent Court of Arbitration, National Data Governance Framework, issue of wrongful confinement, whether it violates the right to life or whatever. Then constitutional validity of the 97th Amendment Act 2011 and cooperative societies. In fact, 97th Amendment Act 2011 has been declared unconstitutional by applying two theories which emerged from Article 13 of the Constitution. One is the rule of severability and the other is the doctrine of eclipse. So these two doctrines also could be quite important so far as 97th Amendment is concerned. And overall, in general, cooperative societies and the related constitutional provisions or the challenges before the cooperative societies may also be asked. Then we have 105th Amendment Act and its significance. Fine imposed by the Supreme Court on political parties on the issue of disclosure of candidates with criminal background. Then we have CJI's opinion on custodial torture and police atrocities. Then electoral bonds and how do these bonds work. Tribunal reforms including the Central Administrative Tribunal. Then we have bonded labor and the Constitution of India. We have comparison of pardoning powers of the President and Governor, including the issue of Section 433A of the CRPC, which has been again recently in news. The court has given precedence to Article 161 of the Constitution over Section 433A of CRPC. Then we have Supreme Court on anticipatory bail, the guidelines. Then Attorney General and contempt of court, e-court integrated mission mode project, role of NALSA and legal aid in India. Then we have alternative dispute resolution, Governor and Lieutenant Governor as constitutional authorities. Then UAPA and related issues, Aircrafts Objects Bill 2022. Then we have Hyderabad Declaration on e-governance, political neutrality of civil servants, challenges of judicial infrastructure and delivery of justice, Supreme Court's guidelines on protection from arrest, reforms in India's criminal justice system, Surrogacy Act and related issues, controversy over Places of Worship Act, right to conversion as a fundamental right, then reforms in labor laws, Immigration Bill 2021, the Real Estate Regulation and Development Act RERA 2016, decision on election symbols, pre-legislative consultation policy. Then we have lateral entry in bureaucracy, role of speaker in disqualification, legal and constitutional aspects of defamation, delimitation commission. So these are the topics which we have picked up for you for Mains 2022. That includes, as I said, both the conventional, important conventional topics and the most recent and emerging topics. So we do hope that you would get the questions which you want and you would be able to write the answers properly. Now let's see the questions which we have framed for you, and that way On your screen, we are seeing the question, important prospective question, the answer format also. But while discussing this, I'll tell the facts and figures which are required to be written or incorporated in the answer. I'll also tell you how to write this answer seeing the format. Let's see the question first and try to understand the demand. Question says, what is the status of the right to be forgotten in India? How does it relate to personal data protection? Discuss. Now see this, the question demands a status, means the position, whether it is recognized as a fundamental right, whether it is still in debate, whether it is a part of Article 19, whether it is a part of Article 21, what is the position, current position of this right to be forgotten. It means you have to write about the present position of this right, that is one. Second is we have to discuss what exactly is meant by right to be forgotten. That is again very, very important thing. The third is how does it relate to personal data protection? And why do we need data protection in fact? So, this question demands at least three things. One, what exactly is meant by the right to be forgotten? The second is what is the current position of this right in India and whether it is to be recognized or whether it is recognized as fundamental right. And the third is its relationship with the data protection. The format says that we have to write the concept of right to be forgotten. Then where is it provided? That is in Data Protection Bill. Status of right to be forgotten under right to privacy. Then why is it under debate? Main provisions which would be covered under the bill regarding right to be forgotten, and finally the conclusion. Right to be forgotten simply means that a person, you or me, will have this right to tell the data fiduciary to delete the personal data of mine which he holds. Data fiduciary is the agency, is the person or the agency or the entity which preserves or holds our data, personal data. So this right says that it shall be the right of the individual or the agency to tell the data fiduciary to delete all such personal information or personal data from the website or from its storage. Why? Because that data might be leaked and then it would amount to be detrimental to right to privacy of that person or individual. It means the right to be forgotten shall be a part of right to privacy. Now, right to privacy in K.S. Puttaswamy's case, you must have read, was recognized as a fundamental right in the meaning of Article 21, which incorporates right to life and personal liberty. So the question is that if right to privacy is already recognized and personal data shall be the part of or is the part of privacy of a person, hence why to once again recognize or why to recognize precisely this right when we have already recognized right to privacy? That has made it debatable, or not controversial but debatable. Number of ideas have been put forwarded that if privacy is already recognized, there is no need of recognizing right to be forgotten. Once the data fiduciary leaks the data, or it is somehow or the other leaked, and my privacy is violated, then I may sue that entity, moving the court that right to privacy is violated as a fundamental right, which ultimately violates right to life and personal liberty. Therefore, there is no need to separately recognize right to be forgotten. What we have to write here is that we need precision in modern times, and the rights which are judicially recognized are not to be claimed directly. Therefore, we need to relate it with the right given expressly in the Constitution. Means what? Right to be forgotten is a part of right to privacy. This is recognized as fundamental right under Article 21. And right to privacy will lead to right to life. So, if the data fiduciary has not been able to protect my personal data and the data is leaked, so I will claim that despite the fact that I told the data fiduciary to delete my personal data, he continued with that storage, and that led ultimately to violation of my right to privacy. So I would go for claiming this. Now, for making a claim for this right to be forgotten, I have to correlate it with right to privacy. Right to privacy is also a judicially recognized fundamental right, so it needs to be correlated with the expressly written constitutional fundamental right. Therefore, this has to be claimed through this, and this has to be claimed through this. So why not to include right to be forgotten directly in right to life? Because privacy is quite a broader term, and personal data have become so important recently, and the leakage of data is so, you can say, so much serious issue now that it needs to be claimed if it is, or if something wrong has been done with that. So the Data Protection Bill in its chapter 5 clause 20 deals with right to be forgotten, which says that it shall be the right of an individual to ask the data fiduciary to delete the personal data from the storage. In case of the leakage of data, it shall amount to be the violation of right to privacy and ultimately amount to violation of right to life. The demand for this right to be forgotten is to include it in the meaning of or in the ambit of right to life directly, so that the personal data is well protected and there is no apprehension of its leakage in any case. This is the status of right to be forgotten, and this is the role of the right to be forgotten in India at present. So the answer demands, what is the status of right to be forgotten? Our answer will highlight that right to be forgotten is being demanded to be recognized as a fundamental right in the ambit of right to life and personal liberty under Article 21. The reason behind this demand is that the Data Protection Bill under Chapter 5 Clause 20 provides for this right to be forgotten, which means that the individual has the right to ask the data fiduciary to delete the personal data in apprehension of its leakage. And the third aspect would be that right to be forgotten is already being recognized as a part of right to privacy, but considering its seriousness and considering the importance of this particular right or importance of the personal data, the demand appears to be justified and rational that it should be included in the ambit of Article 21, and if it is done, it would definitely ensure the protection of personal data at any level, and that will help us to protect the privacy, and ultimately the dignity of a human being or dignity of an individual. This way we can write the answer, and this way we can understand the demands of the question. The second question says, why has the center demanded an extension to make rules for enforcing the Citizenship Amendment Act 2019? What will be its impact? The question says, why has the center demanded an extension to make rules for enforcement of CAA, Citizenship Amendment Act 2000, and what will be its impact? So what is Citizenship Amendment Act 2019? A brief note on that thing has to be written. Similarly, we have to write that why do we need such rules? Can we say that without making rules, the enforcement of an act is not possible? Yes. Then the question arises that why did government not make such rules if the act was passed in 2019? We are already in 2022. And still the government wants an extension of that period to make such rules. So need for the rules to implement the act. Then why is it delayed? Why not the government has made such rules so far? And then the demand for extension of time for making the rules, and then finally we will have to conclude that if the rules are made, what would be its impact on the status of Citizenship Act 2019? So remember, Citizenship Act 2019 basically amends the Citizenship Act 1955, and that Citizenship Act provides for various definitions, and in that definition, illegal migrants is the most important. The amended act says that the persons from Pakistan, Bangladesh and Afghanistan who belong to various communities, ethnic groups except the Muslims, if they have arrived or entered India until 31st of December 2014, they shall not be treated as illegal migrant, and they shall be granted, or they may be granted, India's citizenship. For them, they have to live here for 5 years instead of 11 years, which was provided in Schedule 3 of the main or original Citizenship Act. The point is that the concept of illegal migrant is amended, and 3 countries have been identified: Afghanistan, Bangladesh and Pakistan, and all communities, minority communities in these 3 countries, Afghanistan, Bangladesh and Pakistan, like Hindus, Sikh, Buddhists, Jain and others. So if they are minorities in these countries, which they are, if they have entered India until 31st of December 2014, they would be eligible to file a petition or file an application demanding for India's citizenship after residing in India for a period of 5 years instead of 11 years, which has been amended again. So Section 2 of the Citizenship Act 1955 and Schedule 3 of the Act have been amended, and for that purpose you need to have rules to implement or enforce these provisions of the Act. Unfortunately, the rules have not been made so far by the Government of India, and the reason behind is that Government of India has not been able to finalize ultimately the total number of such migrants, and the National Register NRC has not been finally approved by the government, because they are still in the process of research and collection of the data and analyzing the data. So they have to wait for some time for making such rules. Meanwhile, the government has asked the court that we need to get more time because of this reason, that we are still in the process of data collection and analysis of data or interpretation of data. Once it is done, then the rules could be made, and after the rules are made, it would be able to, the government would be able to enforce the amended provisions of the Citizenship Act. Now, once the rules are put in place and once the Amendment Act is enforced, then the advantage would be given to all those people who migrated to India from Afghanistan, Bangladesh and Pakistan until that date, cut-off date, that is 31st of December 2014. And once they are residing in India for a period of 5 years, they would be granted, or they might be granted, citizenship of India. So the inclusion of these migrants, which are not to be treated as illegal migrants, would be possible only after the rules are made and only after the provisions in Amendment Act are enforced. So this way we can write the answer of this question. The third question says, the recent order of the court that sexual act by husband does not amount to rape has triggered a controversy in India. How far do you think that it would affect marital relations and position of women in the family? So we have to identify the demands here. Court has said that husband has made a sexual act with his wife, but that is not rape if it is not with her consent. Even then it is not a rape. And that has triggered the controversy that why not we should consider it as anti-woman step or anti-woman decision, that even without the consent, the husband has performed sexual act, and that would amount to violation of the dignity of woman. And that even if she is wife, it does not mean that her dignity should be violated. So the critic of this judgment or decision are of the view that this decision would finally damage the dignity of women, especially wife, and marital rape should be considered as a serious offence under Indian Penal Code. The concept of marital rape we have to discuss, its legal aspect in IPC under section 375, main points of the order of the court, reasons for becoming it controversial, and how will it impact the position of women in families. The section 375 defines the term rape, but the exception 2 of this section says that if the husband has performed sexual act and if the wife has not attained the age of 15 years, then it amounts to an offence. Earlier it was, which has been raised, the age has been raised to 18 years now. Therefore, even if the husband performs a sexual act with his wife, with or without consent, unless and until she has attained the age of 18 years now, it shall not amount to rape. If she is less than 18 years, then it may amount to rape. Otherwise, even if the wife has not given consent for sexual act, and if she has attained the age of 18 years, it does not amount to rape. That is what exception 2 of section 375 of IPC deals with. The supporters of this concept that marital rape should be declared as an offence, they have pointed out, or they feel, or they say that without consent, sexual act without consent, even by the husband, shall be considered as rape because it is a sexual offence. The logic is there, no doubt, but do we have other provisions also? There are a number of provisions, number of laws, number of sections in IPC which deal with sexual offences against women, and a person may be targeted, or he may be sued for such offences under any of the sections of IPC or under any other law. So even if section 375 exception 2 is not removed, it does not mean that the person who has committed a sexual offense even against his wife shall not be punished. He may be punished if the wife comes forward and files a case. He may be punished for that sexual offense. What the court says that the sexual act in the marriage in India is you can say inbuilt in the concept of marriage. Why it is so? Because marriages in India have an element of sacramency, and it is not always a contract. So it is a kind of sacrament, and that sacramency includes the sexual relationship between husband and wife, and that consent is inbuilt or it is inherently present in the concept of marriage. So the sexual act performed by the husband shall not amount to rape unless and until the wife has not attained the age of 18 years. So that way the logic should be that despite the fact that the critics have pointed out this, the judgment given by the court should not be considered as against women's dignity. Rather, we could say that it protects the sacramency aspect or sacrament aspect of the marriage in India, and it also says that even if the exception 2 remains in the law, there are number of provisions under which a person may be punished if the wife wants, if the wife files a case, he may be punished for committing a sexual offense against his wife. So that is what the question demands, and that way it will not damage or denigrate the position of women in the family. The woman, if she wants to file a case, she is free and she has the right to go to the court or move the court for that purpose. The next question says, what are the provisions for checking exploitation in the Constitution of India? Do you think that these would help rehabilitate bonded labor? Discuss. So we have to write what is exploitation, and the constitutional provisions, articles 23 and 24, rights against exploitation. Major provisions in these articles and their possible impact, their relations with other laws, bonded labor and requirement of their rehabilitation, and finally conclusion. Exploitation is generally done when a person is misused in his working without his will or without his consent. However, sometimes he is forced to give his consent to do so, because the situations are created that way that a person in that situation is not able to counter that, and he is forced to or compelled to give his consent. That could also amount to exploitation. If he is performing or doing unwilling work, that is definitely exploitation. Even if he has given his consent, the employer will say that no, he has given his consent. But whether that consent was forcibly taken, that needs to be ascertained, that needs to be found out. So exploitation is generally unwilling work or forced work done by somebody. The provisions are Article 23 and 24. Now Article 23 deals with three things you must have read. You should revise it also. One is human trafficking. Second is begar, and third is forced labor. These three are prohibited. And Article 24 talks about prohibition of child labor. These two are the main constitutional provisions in India. Human trafficking is sale and purchase of human beings as goods for the purpose of exploitation, including sexual exploitation. That is a general broad concept. For exploitation, including sexual exploitation. There, especially for girls, it is very, very important. So, this is human trafficking. This sexual exploitation includes immoral trafficking of women and girls also. Women and girls. Therefore, Article 23, Clause 1 is directly related to Section 366A and 366B of the Indian Penal Code. Related to which deal with that trafficking of girls below 18 years interstate within the national boundaries and international shall be a punishable offence. It is also related to Suppression of Immoral Traffic Act 1956. Therefore, Article 23, Clause 1 prohibits human trafficking to prevent exploitation of all people, especially women and girls, by prohibiting immoral trafficking and by making this kind of trafficking an offence punishable under law, and for that number of sections are there. Precisely two need to be quoted, Section 366A and 366B of the Indian Penal Code. Similarly, we have the concept of begar and forced labor. Let's see this. Forced labor. Unwilling work, paid or unpaid. This is forced labor. That includes child labor, bonded labor, contract labor, etc. If the forced labor or unwilling work is unpaid, then it is called begar. Unwilling, unpaid work, that is begar. So the article says that begar and other forms of similar forms of forced labor. The most significant of all this is bonded labor. They have signed a bond that they have to do this. They are forced. And most of the time you will find that bonded laborers are doing begar because they are unpaid very often. Therefore, we need to rehabilitate them. There was a case, Bandhwa Mukti Morcha versus Union of India, 1984. So based on that, bonded labor rehabilitation is initiated in India, and uh, and the government has ensured that this kind of labor should be prohibited, and all such labor should be, or workers should be released and rehabilitated, compensated, so that they are able to sustain their life and they are once again included into the mainstream of development. So we may refer the case Bandhuwa Mukti Morcha versus Union of India, 1984. This is one aspect of the exploitation. Here we have to understand Article 23, Clause 2. It says that if the state wants, it can take or it can secure compulsory service for public purposes, and that should not be considered as forced labor. So we need to understand what are compulsory services and what are public purposes. It also says that while doing so, the state shall not discriminate only on the grounds of religion, caste, place of birth, religion, caste, then sex and place of birth, what we have in Article 15. There are two words missing in this and one word is added in. So sex and place of birth. So these two words are missing in Article 23, Clause 2, and a new word has been added, ground for discrimination, that is class. So Article 23, Clause 2 prevents discrimination while taking compulsory services for public purposes on the ground of religion, race, then class, caste, but the place of birth and sex have not been included. So we say that while these two words are missing in 23 Clause 2, the word class is missing in Article 15 Clause 1. And in that sense, Article 23 Clause 2 is considered as an extension of Article 15 Clause 1. What are compulsory services? Compulsory services include two types of services. One, social services, and second, services for national security. And public purposes include all such purposes which have been enshrined in Part 4 of the Constitution in the form of directive principles of state policy. Public purposes enshrined in directives under Part 4 and compulsory services include two. Social services and services for national security. This is under Article 23 Clause 2. So one thing what we have to remember is provisions for exploitation, checking on exploitation in the Constitution. We can write that there are two provisions directly related to this check on exploitation in Part 3 under Article 23 Clause 1 and 2 and Article 24. 23 Clause 1 prevents and prohibits and declares any such act as an offence. That act is human trafficking, begar and other similar forms of forced labor, which we discussed that human trafficking is sale and purchase of goods, sale and purchase of human beings as goods for exploitation, including sexual exploitation, is called human trafficking. Since It includes the concept of immoral trafficking in women and girls also. So it is directly related to various sections of IPC, precisely section 366A and B, which prohibits or declares the interstate or international trafficking in girls under 18 years of age punishable offence. It also is related to Suppression of Immoral Trafficking Act 1956. We discussed that forced labor is unwilling work, paid or unpaid, and if unwilling work is unpaid, it is begar, which we find mostly the bonded labor. Therefore, they need to be released from that kind of employers, and they need to be rehabilitated, compensated and resettled. We can refer the case Bandhuwa Mukti Morcha versus Union of India 1984, based on which the state has taken steps for the release of such bonded labor, and they have started working for rehabilitation to include them once again into the social economic mainstream of development. Article 23 clause 2, for your reference, for your revision, it empowers the state to take compulsory services for public purposes, and for that reason it shall not discriminate only on the grounds of religion, race, caste and class. And we said that Article 23 clause 2 is an extension of Article 15(1). The reason behind is that while Article 15 clause 1 does not include the word class, Article 23 clause 2 does not include the word place of birth and sex. Therefore, it is considered as an extension. Coming to Article 24, it prohibits child labor. It means that no person shall be employed in mines or hazardous industries if he has not attained the age of 14 years. So, Article 24 prohibits child labor and is directly related to the Child Labor Prohibition and Regulation Act 1986. Article 23 and 24 will serve the purpose for writing answer to this question. We have the next question. Equal justice and free legal aid is one of the pillars of an egalitarian social order in a country like India. Comment on this statement and discuss the role of the National Legal Services Authority, NALSA, in providing such services. Equal justice and free legal aid. What type of concept it is? That is one. Under Article 39A. What is meant by egalitarian social order? Why did we require this concept of equal justice and free legal aid? What is the act named? National Legal Services Authorities Act 1987, under which such authorities have been set up, including at the national level, that is NALSA. And what does NALSA do? These are the aspects which we need to write in our answer. Now let's talk about this. This is under Article 39A, inserted by 42nd Amendment Act 1976. Equal justice. Everybody should be given justice. Per capita justice must be ensured. That is one. Why it is so? Because Indian social order shall be egalitarian, based on equality and equity. every individual, every person shall be provided with the resources which are due to him. Everybody should be given those resources according to his or her requirement. That's what we say, distributive justice. So, equal justice and free legal aid is the outcome of distributive justice, which emanates from Articles 38, 39 and 46. Now precisely 38, 1 and 2, 39, B and C and 46. 38, 1 and 2 deal with equality at individual and group levels. 39B and C. 39B talks about community ownership of material resources. And 39C prevention of concentration of wealth and means of production. And 46 deal with welfare of weaker section. These are the components of what we call distributive justice. It means when we talk about egalitarianism or egalitarian social order, it is founded on the principles like equality, it is founded on the principle of socialism and welfareism. So free equal justice and free legal aid, when we say that it is the outcome of distributive justice, it will yield into creating the social order egalitarian, definitely. Next aspect what we can write is that distributive justice founded on the principles of equality, socialism and welfareism. And these two will constitute egalitarian social order. To achieve this, goal, Article 39A was inserted, providing equal justice and free legal aid. Every individual should be given that. Based on this concept, Legal Services Authorities Act 1987 was passed, under which NALSA was created, National Legal Services Authority. This Nalsa provides equal justice and free legal aid. Therefore, for a common man who cannot afford a legal or law professional, if they approach Nalsa or the state level authorities, then free legal aid would be provided to them, and that would help him go for protection of his rights. For example, a very popular case you must have read, Nalsa versus Union of India 2014, in which case the court recognized the transgenders as the third gender. So it delivered justice to transgenders also. Provides free legal aid to deliver equal justice and to protect individual rights. This is the role of Nalsa. Makes people aware of the legal aspect. Nalsa versus Union of India 2014. Transgenders recognized as the third gender. This is what the question demands. This way we can continue with few more classes, and I'll discuss these questions like this what we talked about today. In the next class also we'll discuss some of the questions, maybe 5, 6, 7 depending upon the requirements of the questions. And once again I would suggest that whatever sources you have at home, you should revise the conventional topics, and if you continue with the classes, you will find that you are not only revising the syllabus, you are also covering more or less everything, and you are able to identify and understand the demands of the question, and you would also be able to understand what are the facts and figures and analytical aspects needed in your answer. Accordingly, you can write, and as I had said in the beginning, you can send your answers through WhatsApp, for which you can use this phone number 93-130-58532. This number can be used for sending your answers on WhatsApp, and once we receive, we will review those answers. We will make suggestions if needed. We will say whether your answer is good or bad, emphatic, powerful, whatever, whether according to the need of the examination. So in the next class, we will continue with some more questions, and accordingly we will discuss the facts and analysis of the constitutional provisions or the provisions related to governance in India. Thank you very much.